say, cannot keep a pin. Cannot keep it. That's a pro. You can keep it pin. Never keep it fit. Excellent.
I agree. I agree. Right support. You did it. Right. Quick one.
Mr. Speaker, I rise to make my contribution to the debate on this bill entitled An Act to Amend the Jury Act. The bill is seeking to do two principal things, though stated in three. It is increasing the sum that is paid to jurors who serve. And that amount is being increased to provide for a payment to those who are summoned to serve for jury duty and those who actually serve as jurors. I do not believe there is any divide on the timeliness of this proposed increase. Everyone who has spoken so far has indicated support for this move. It is something that we have spoken about time and again, but had not done. And I want to commend the amendment for support. However, Mr. Speaker, we should make it abundantly clear that we are not paying citizens to serve as jurors. In the context of the justice system, the jury is not a profession for which you are paid. But in the Jamaican context, it is recognized that many who are summoned to serve as jurors incur expenses that should be defrayed. And I think it is in the spirit of that incursion of expenses that the increase is made to take care of the inflationary impact on the existing amount. So it is without a doubt a good move, but all citizens are to understand that the civic duty to serve as juror, trying your peers, is not one to be seen as a profession. And so it's not intended to create professional jurors simply because you are being paid. But the increase is a proper increase and should be supported. The other main point that the bill is addressing is in response to issues raised in the Sean Campbell, Deja Palmer et al. Trial in respect of a gap in the Jamaican law on the jury system. And this is a matter, too, that is commended for support because it is not in the interest of justice to have a case tried. If we use the Vibes Cartel case from which the point arose as an example, the length of time that it took for the trial to be held, and then the length of time that the trial itself took, only to find that the court on appeal had to send back to our local courts consideration whether a fresh trial should be done. And the interest of justice did not demand, after so many years had elapsed, for an additional trial to be ordered, a new trial to be ordered. And so empowering the court and a judge to discharge a juror where there is evidence of jury tampering and continuing the case without having to start de novo is something that needed to be addressed. And this bill is addressing it, and it has to be supported. When I served as Attorney General, Mr. Speaker, time and again, I came to this House in previous parliaments asking members or commending an approach to members. I've always found it helpful to debate the actual provisions of a bill instead of speaking at large on the subject matter. And it really doesn't take away from the thoroughness of preparing a bill before it comes to Parliament for proposals, for amendment to be made on the floor. At the end of the day, you want to ensure that what is drafted is achieving the intention of Parliament. And that is why you pay close attention to what is drafted. Having said that, I indicated to the minister piloting the bill that I would be proposing just a few amendments for consideration. Starting at clause 2 of the bill, I have no issue with clause 1, which deals with the short title and construction. At clause 2 inserts a new section 1A and inserts a definition section in the bill. In our Jamaican law, the definition section usually comes at clause 2. But since this is an amendment to a very old legislation, in fact, the Jury Act was first promulgated in 1890, I believe it was 1898. And since then, we have been amending it, coming down to what is proposed today. So a new definition section is being inserted, and it's good practice. It is in keeping with our own legislative standard, for want of a better word. It begins with a definition of jury, to simply say that it includes, comprises special jurors. And special jurors are selected when a case necessitates examination and consideration of accounts or documents involving questions that are unusually complex. The jury list is defined to mean the list that is prepared in accordance with Section 7 and settled in accordance with Section 13. I should like to propose an amendment to substitute the word settled with certified, because the settlement of the Jury Act is actually done in accordance with the sections 8, 9, 10, 11, and 12. Certified. So what happens at 13 is after it is settled, then it is certified by the judge. So we would delete settled and substitute with a certified. No issues taken with the other definitions, save and except that when we go to clause 3, which introduces the insertion of a new section 2.6 for the trial readiness hearing, I think it was pointed out that this is new. The minister indicated that, and the member from Portland Eastern made some comments on the difference between what is being incorporated in the bill and the entire framework that exists in England. And I think his comments are worthy of consideration. It takes nothing away from what my learned friend, the member from Trelawney Northern, pointed out. Just to say that insofar as the comparison in the framework is concerned, what is stated here is that the trial readiness hearing means a hearing that is presided over by the judge, at which it is determined whether the trial date, which was already set, can be confirmed. Now, what is set out for consideration are matters, properly speaking, that should be taken into account before a date is set. And so it does raise some questions as to whether the inclusion or the addition of a trial readiness hearing when a trial is already set will not operate to prolong proceedings and delay proceedings. And I believe that is the point, if I understood it, that was being made. Because what really should happen before a trial date is set is that the judge must be satisfied that the case is ready to proceed. And that is why a trial date, the setting of a trial date, is preceded by numerous other dates, commonly called mention dates. And then you have hearings around whether the case can be mediated and settled otherwise than by trial. So my question is whether this should precede the setting of the trial date. Now, the factors that are set out there, again, for emphasis, for the most part, should precede the settling of the trial date. But given the number of cases that are before the court and the fact that dates are being set far, you can have intervening matters between the setting of the date and the actual commencement of a trial. And so I think if the trial readiness hearing as proposed is to continue, then how it would be meaningful is to consider whether any new issue or any change in circumstances have arisen between the setting of the date and the actual starting of the trial that may affect the duration and the conduct of the trial. Those are my comments on clause 3. Clause 4, clause 5, if the intent, as I understand it, is to reimburse and defray expenses incurred by jurors in their travel to and from the point of court, then we would want to make payments to jurors and other persons instead of payments of, which gives, conveys a different message. Clause 5 proposes a repeal and replacement of section 35 and of section 35. Clause 6 repeals and replaces section 36. Clause 6. Now, clause 6 refers to fees and expenses. In the Principal Act, the payments that are made to jurors are paid in respect of the jurors traveling to and from the place to which he is summoned. And so it raises a question as to what other fees are contemplated if the wording is that there shall be paid a person who serves as a juror in a criminal or civil trial shall be paid such fees and expenses. So the question is, what type of fees are contemplated for payment to the juror other than the defraying of expenses incurred? And if no fee is being contemplated, then I would commend for consideration an amendment which would be more in keeping with what already exists in the Principal Act. About payment, I crave your indulgence. Essentially, payment to defer the expense of traveling. Unless, of course, other fees are contemplated, and if they are, then I don't know what they are. But bear in mind that we're not creating professional jurors. We're really defraying the expense that is incurred by them to travel. See, the administration of justice is a very fragile thing, and you really have to be careful what you incentivize or not incentivize to ensure that justice is done at the end of the day. Clause 7, which repeals and replaces section 37, at 37.3 speaks to compensation. The same comment would apply if it is a payment to defray expenses as opposed to paying for the service. So perhaps the word stipend may be more appropriate there, or for expenses. No. The matter of trial without jury is a matter that has become somewhat contentious, or I should say that has always been contentious. When the Charter of Fundamental Rights and Freedom was being drafted, if you look in the documents, you'll see that there was advocacy for a constitutional right to trial by jury. And after extensive hearing, it was determined that it would not be in the interest of justice to provide for a constitutional right to trial by jury. And so it was not included among the new rights that were enshrined in the new Chapter 3. But the right was created at a lower level in the law. And since then, we have had changes to mode of trial. So trial by jury and trial by judge, bench trial, jury trial are referred to as modes of trial. And at the end of the day, whatever the mode of trial, the interest of justice has to be served. In Jamaica, the matter has been debated at length in many places, and I think the debate will come to the House in due course, as the Minister has said. But it should not be lost on anyone that across administrations, we have scaled back trial by jury for good reason. It was done when the member who sits as the leader of the opposition served as Minister of Justice and piloted a number of bills. And there were good reasons for doing so. What I have heard many times is that the executive and legislative branch of government can trust the judicial branch for guidance on many things. And so the call for consideration, further consideration on the modes of trial is one that has to be listened to. What is being proposed here is not whole-scale abolition of trial by jury. And I think there seemed to be some misunderstanding, even though it was acknowledged that what is provided for is a partial doing away of trial by jury. But let us look at what is being proposed here. The proposal is empowering an application to be made for trial by judge alone in very specific circumstances, where trial by jury would not serve the ends of justice. So it focuses exclusively on jury tampering. And where a juror or an entire array, the jury, has been improperly approached, for a juror or the jury to be influenced, that may be for or against either side. And if there is ever a proper case to provide for a discretion for trial by bench alone, is in circumstances where you have jury tampering. I don't think it gets any higher than that, because the mode of trial is a means to an end, and that end is for justice to be served. So, notwithstanding the discomfort that revision of the Jury Act is coming soon, and it will allow for wider discussions on the matter, I do not see any injustice being done by what is being proposed at this time in the very limited circumstances. I would only say that in keeping with what the board pointed out, and which I will repeat for emphasis. An improper approach to a juror may influence that juror for or against a defendant. And I would add for or against the prosecution. And so at the proposed 42B, subsection 3, where it says that the judge may order that the trial is to continue without a jury if the judge is satisfied that jury tampering has taken place, and to continue the trial without a jury would be fair to the defendant. That is kind of one-sided. It must also be fair to the other side. And it shouldn't be against one side and in favor of the other side. So it's really where the interest of justice require. And that, I think, is what you, the proposed 42C speaks to for the termination of trial. But it would require some tidying up between the proposed 42B and the 42C. I move to the amendment to the regulations. And, Mr. Speaker, many times in the past, we have heard complaints that Principal Act are being amended and the attendant regulations are not amended. Well, here we have both the Principal Act and the regulations being amended at once. My same comment in respect of the non-payment for the work as a juror, but for defraying expenses. Then the amendment to Regulation 2.1, which speaks to payment for participating. Well, it says to cover the expense incurred for participating in the jury selection process and the traveling. That sets it out because it makes it clear that is those expenses that are incurred for those purposes. So, Mr. Speaker, I've always said that I don't like piecemeal amendments. And I have drawn a distinction between piecemeal and incremental amendments. This bill kind of fall in between the two. But what is being proposed is important. is important. So supporting the increase, it doesn't make sense putting off the empowering of the judge to continue with a trial where the jury has been tampered with to another time. And for that reason, I believe the bill should be supported, and I commend it for support.